Thank you for being here at the Don't Get Hurt Twice podcast. My name is J. Chad Parker. I'm a personal injury trial lawyer. I've been practicing almost 30 years and I'm board certified in personal injury trial law. This podcast today is going to seek to address the issues specific to people that get injured in the oil field. It should be a given to most people, but all lawyers are not as qualified as others to represent people in the oil field. They don't know anything about the processes. They don't know anything about the obligations of the companies, the operator, their own employer. And if you don't know kind of the rules of the road, it's tough to make a case or at least have a good outcome. Oftentimes, there's a dispute between who's in control. The right of control is an operative word not only in Texas case law as it relates to oil field actions, but also in master service agreements, IEDC contracts, and it really shifts the liability to the one that was, quote, exercising control or in control. And that generally, the better a lawyer is in the oil field at knowing what can and can't prove that someone else was actually in control leads to a good outcome. It leads me to a story of a guy I represented, and I'm sad to say that I found out about 6 months ago that he'd committed suicide. He had been over in Iraq and Afghanistan. He was a relatively young guy. He was in his 30s. He worked for a oil field service company. It was a snubbing unit that he worked on, which was a workover rig, and in an operation where this is sometimes they call it sim ops, simultaneous operations. Two companies are working together, so each one is in control of doing something. Now, somebody can get hurt, and then the argument becomes, hey, who was in control? Anyway, in this case, there was somebody else in charge of equipment that ultimately led to him having a finger taken off. Now, he had a workers' comp claim, and thankfully for him, he saw a few doctors along the way, but there's really not much you can do about an amputated index finger, right? I mean, it's gone. It's sewed up. The infection is past, if there was any. And you just go forward, and you've got some disfigurement and some impairment there. But, hey, he's not the first guy you might see in the oil field that's missing a pinky or an index finger or a finger missing, right? I mean, those are tough guys. I mean, you don't often think, hey, I'm missing a finger. I can't work ever again. That's not where this story goes. You know, a good lawyer also has a good grasp on medical issues as well. In this case, his workers' comp doctors had seen him, and he had developed chronic regional pain syndrome, or at least we could make that allegation because it was in the records. But liability was the biggest hurdle, and that was the thing. It was, how could we prove that what you would normally think is the driller, but is oftentimes called an operator who was running the workover rig. They were picking up pipe. Who was at fault? Well, ultimately, because of my knowledge of the oil field, I think I could make the better arguments, write demands, cause the insurance company to question and ultimately pay, not what I demanded, of course, but ultimately the settlement, went to $1.15 million. That was the settlement. Now, to ram home the point I'm trying to make, do you know I was the fifth lawyer that this gentleman came to see? The fifth. Now, you go, what in the world? How did four other lawyers not see a $1.15 million settlement? Well, they gave up on liability. They knew the guy had a missing finger, right? It was obvious in the meetings. They knew his medical records said chronic regional pain syndrome, if they were paying attention. Because a lot of times in workers' comp records, they don't try to lay it out there. They kind of hide it. And so they used initials like CRPS. They didn't spell it out. But anyway. No, the other lawyers gave up on liability. They thought, oh, my God, I'm going to have to prove liability. I might have to get an expert, pay an expert. It looks like it was his employer's fault because he was in the basket with them and, his hand got pinched. He should have just kept his hand out of the way. And they rationalized four lawyers prior to me. I say that's a prime example of, picking up the crumbs. That is, other lawyers discard good cases, which for people that really need help every day that don't think there's anything there because they think it's not worth the risk. I'm telling you, that's a prime example of how one person, finally, me, who had worked for oil and gas companies as their defense lawyer for 20 years, saw in it enough to put money into it, time and effort. And it paid off. And who did it benefit? The injured worker, the oil field worker that sometimes has to go around trusting this lawyer or this lawyer knows what they're doing, and they have no idea. And so for the oil field workers who have been hurt, you either had a good experience, a so-so experience, or a terrible experience. If we visited, I could only imagine what you would say about what you thought your lawyer's knowledge level was of the oil field and how that hurt the case. Because maybe the other side had superior knowledge, that is the defense lawyer, and where that comes into play is when you are being asked questions by the other lawyer. How can I prepare you for a deposition as your lawyer if I don't even know the questions to ask? If I don't even understand the process that you were involved in, the equipment that was being used, and how it is, how you run it to determine who's at fault and who might not be or who probably was. I mean, it makes perfect sense, and I think the public and maybe oil field workers in general think, well, you know, anybody's a lawyer. It doesn't matter if you're a board-certified lawyer at this point. You've got to go a step further and find out, well, I know they're board-certified, but have they ever handled any oil and gas accidents before? And if so, were they just simply, you know, trucking companies that were hauling oil field pipe, where a piece of pipe rolled off on a guy, or was there a blowout? You know, when somebody says, the well took a kick, does your lawyer know what that means? When somebody says, hey, we nippled up the BOPs, do they know what that means? If somebody mentioned the word, hey, we were flowing the well back and this happened, would they even know what they're talking about? Okay? Depending on the kind of well, people that are listening that have any kind of, history in the oil field, they understand, depends on the type of well. I mean, there's artificial lift, which would have, there would be product in the tubing and there could be annular gas. And there are issues, that have to be dealt with. Most of the time with those, it's a workover. It's a workover rig. It goes back out there, there's holes in the tubing or there's some other issue of maintenance. The pump's not working. Things have to be done. And of course, it's the operator's well. That is the owner. Let's just use an operator in no particular order or not related to anything. Let's just say many people have heard of Chesapeake, for instance. They had a lot of gas wells, spent a lot of time buying up leases, in the state of Texas over the last several years, leading up to, kind of the decline we're in now. Anyway, that's an operator. They hold the title, okay? They own the minerals under the ground. They have leased them from different landowners, different mineral owners that have owned them, and they may have leased them at different levels. That is, at formation levels. Hey, they leased, 500 to 6,000, but they didn't have 6,000 to 8,000 or whatever. And as you well know, there's geology that's done surveys that are taken down hole, and a decision is made to do things like shoot perfs, which means perforations, and it comes from guns, which aren't guns, but they're wireline guns. And, that opens up the formation and allows, oil and gas to flow to the wellbore, and there are just issues about understanding that and how that contributes to pressure in the hole, above hole, potentially, kicks, migrating gas, things of that nature, that it's one thing to pretend like you understand, okay, I know there was a blowout, a guy got hurt. It's yet another to be able to explain the mechanics of how that happened because of something that somebody did or did not do. For instance, hey, you should have put some fluid on the hole. I mean, what the world? You hadn't put any, you put, 30 barrels on it, and we had some delays along the way, and then, it's 6 hours later and no fluid's been put on the hole, and boom, there's a kick, and then if there's a kick, then everybody knows in the oil field that's bad because The next thing that happens, unfortunately, in a lot of circumstances, is that kick ignites. And then you've got a blowout and you've got a fire. And so there's metal everywhere, static electricity. There's many ways in which a kick can turn into, an explosion. But that's just an example. A lot of injuries, like you say, or like you probably know, are different, back injuries, fingers, many of the things that are covered in, the JSAs that are done before the job starts. Watch your pinch points, this, that, and the other. Keep your hand off the wire line, those type of things. But the serious injuries where it really matters, that is, where somebody's seriously injured or killed. I mean, just somebody with, knowledge of the oil field that they picked it up in a book at the bookstore called, Oil Field Knowledge for Dummies is not the lawyer that you want to handle this kind of case. I mean, you're talking about the difference between demanding, a million versus millions and being able to prove it and making them afraid that you can expose what happened and shouldn't have happened and how it was negligent or even grossly negligent. And obviously the second element of that is a lawyer that's got enough skill to prove up all your damages in a way that they can present it to the jury and maximize your chances once the jury hears your case and whatever those facts are in returning a verdict to you that's fair for you and your family. The oil field is unique. There are certain pressures. That is, there's this pretend openness that everybody's in charge of safety. I mean, and you guys who are listening, you know what I'm talking about. Anybody can shut down the job in the new oil field, okay? That is the stated policy of the entire oil field. And coincidentally, it spreads all of the blame onto you and your company and not them because, hey, you should have shut the job down, right? That's what they say. But at the same time, everybody knows you refuse to do something, they're going to walk you off the job in many instances and have. And that's an unspoken rule underneath the spoken rule of anybody can shut down the oil field. Anybody can shut down the job in the new oil field. So your employer has workers' comp most of the time and doesn't want to claim either. The operator doesn't want any type of lost time accident on their location. Your employer doesn't want to have any accidents on their record because it affects their ability in a kind of computer algorithm that ranks companies as far as hiring, and they think it might hurt them. So everybody's against you accidentally if you get hurt. Your employer doesn't want you to file a claim. Your employer doesn't want to blame the operator if they were exercising the right of control that caused you to be hurt because they're afraid they might lose work. And certainly the operator doesn't want to accept responsibility and say, oh, I'm sorry, we shouldn't have done that. To top it all off, the contract that your company entered into with the operator most likely says if your employees get hurt, then their insurance company, that is your employers, will defend the lawsuit and pay the damages with the insurance that they were required to carry because the operator said you had to have this in your contract if you want to work for us. So I call that the blame game in the oil field. That's the game that gets played when somebody gets hurt. And most often all the fingers end up getting pointing at you. The guy that gets hurt obviously is doing something or a part of a process that results in his injury. And so whatever that is, everybody can say, well, hey, you shouldn't have been doing that, or you shouldn't have done that as fast, or you should have been more careful. It doesn't matter if they were running the rig too fast. It doesn't matter if they should have been working a lot slower. It doesn't matter if they should have shut down because it was getting too dark and nobody could really see. So, there are recommended practices in the oil field. That is, they're copyrighted. Essentially, they're not regulations, but they're recommended practices. But they carry the weight of, what's customary in the oil field. Okay, and they emanate from API. Okay, American Petroleum Institute. And so, some lawyers don't even know they're out there. And oftentimes they lay out the process that should be followed in an operation. And of course, if there's a deviation by a company, I mean, it's almost like a checklist for how to prove what they did wrong by their own regulations of a group, an organization that they're a member of. And so, that cuts down. If your lawyer has that kind of knowledge, like I do, oftentimes I don't hire an expert right off the bat. I gather the information, look at it myself, start to think about what am I seeing. Then the experts use later on, if I need one, in order to answer questions I have, fill in gaps, maybe instruct me on some technical things that I don't quite understand in a way that I can, ask questions better of their witnesses. And what I've done for the oil field worker is I don't have $100,000 in expenses and an expert before we get to the depositions, because that money comes out of your money. And then, most people, when they settle up, they never think to question their lawyer, like, hey, why do we have all these expenses? Well, the short answer is, the lawyer should be able to explain why that expert was retained when it was and how this benefits, the overall. In many instances, people have just accepted that that's a level of, the learning curve that they're going to learn on you, okay? So the reason I'm saying, and have been, a board-certified personal injury trial lawyer doesn't mean a thing right now, other than they could try the case and do a good job, maybe. The other thing is, their competency or proficiency saves and potentially saves a lot of money on expert fees that might have been completely unnecessary in the first place. Imagine somebody who knows what they're talking about. They get all the records. You finished treating, you've recovered, whatever happened to you, you've got a certain amount of medical bills, you lost wage for a certain amount of time. Maybe you've lost some function in maybe your knee, your shoulder, something, had a surgery, and you might need another one in the future. And we've allocated for all that and got a doctor to issue a report or whatever. Well, I make a demand in two ways. I have a liability paragraph where I start with, and I have medical injury / damages of you. In the liability, let's say I know what I'm talking about. And I lay out exactly what happened, why it happened, why it shouldn't have happened, and who was at fault, and what recommended practice or other, standard was violated in clear and uncertain terms. Versus somebody else who just simply says in the liability paragraph, my client was hurt due to your actions. And that's all they say. Which one of those do you think is going to get serious consideration for a settlement, either prior to litigation or after litigation before it gets too deep? I suggest to you it's probably going to be the one where they look at the lawyer that has explained that he or she has knowledge of the process and the oil and gas industry in general, and probably give them a little bit more credibility, which will likely be reflected in the offers. Also, 15 plus years of my career, one of my primary clients was an oil and gas division of a national insurance company. And since I worked in Texas, the cases that I got from them were all oil field related accidents. That means everybody in that case was hurt in the oil field, not in a car wreck, not this, but hurt in the oil field. And through that, what I did was I represented operators, people that owned the well, and hired the company men who were hired by the operator and classified as independent contractors, but generally were completely controlled because the operator had, originated the well prognosis of the well plan that they had to follow. And then service contractors would be everybody from the drilling contractor, if they were drilling a new well, workover crew, if they were coming out to do maintenance or something else, and all the other subcontractors, whether it be wireline, directional drilling, or what have you, that would come out there and all interact in, what the oil field refers to as sim ops, simultaneous operations. When things arguably can be the most dangerous, and when the blame game that I talked about potentially becomes, the most likely for you. But anyway, so with all that as a backdrop, you could quickly talk to me, talk to another lawyer, talk to a person that works in the oil field, and you could tell pretty quick if you just ask some questions, what do they know and what don't they know? Because you can bet this. Anytime a lawyer says or hears, hey, this is an oil field case, they're thinking, okay, like a trucking case. They have to have bigger limits. This is a better case. I'm going to make a better fee, right? Well, here's how they may make that fee if you don't watch out. They sign you up, and then they refer you out to somebody like me or somebody else, okay? Now, why even sign up with them? You know how you avoid that? If you're hurt in the oil field, you're always going to be hurt. It's not like you got to sign up in the next 2 minutes or the next 3 days. Otherwise, you're lost. Like I told you about my client, he got to me after 4 lawyers, okay? It was months before he got to me. So don't worry about that. You know what happened to you. You know what operation you were working on. You know what company you work for and what they were doing. You know what your instructions were and what type of work was being done. You know all of that. Your lawyer should be able to talk with you in a way, if you ask some of the questions and provide him some of the information that alerts you that this person knows very little, if anything, about what you're talking about. And that should be the first clue that this person may not be the best lawyer, even though they may be a great one. It may not be the best lawyer for you in this circumstance. I've worked on so many different cases involving the oil field, some sad cases, some really bad cases. But, the processes a lot of times are very similar to what happens. It's just, well conditions change. People do dumb things, and that changes. And so, a good working knowledge of the oil field, drilling and production, right? I mean, you drill the hole, that's a hole, that's a set of contractors and objectives in order to get the hole drilled. I mean, that's, you start out and you spud the well, and then after you built the location, and then here you go, right? And then if there's a decision to frack the well, of course, the drilling rig's gone, and then they come frack the well. And then once they frack the well is ready to be produced, okay? And, I mentioned flowback earlier. I mean, obviously, after they frack the well, they're going to have to flow back the frack fluid to get it out of there, okay? I mean, there's technology that's evolving. They used to pump gel, that they refer to as gel breakers. It would go down there, and they'd pump it as gel, and it would get in the formation and maybe open the formation a little bit more. And then after time, the heat combination, the gel would break, it'd turn to water, and they'd flow it back out. And there's all these things, which leads to the production of the well. The well gets on production, which means it's making oil or making gas or making a combination of both. That amount is being stored in tanks, separated. You've heard of a separator, being separated into tanks. And then 18-wheelers come and pick up the condensate in one and the crude oil in the other, if that's what it is. And then that well produces, and then it may have to be worked on. And then, the workover comes into play. And so the process, in order to tell a story, to tell your story, I'm saying you've got to know something about it. I hope you oil field workers specifically that have been in an accident now or in the future, hear what I say, ask these questions when you're hiring a lawyer, no matter where you are, and at the end of the day, that leads to you not being heard twice. Thanks.